you in the room are probably familiar with that law. So in the mid 90s, transportation workers were um, flurrying about trying to comply with the DOT regulations and Minnesota's drug testing law. We have one of the most onerous restrictive statutes in the country. And that's when I started working with Lisa and the Minnesota Safety Council, primarily to help employers comply with DOT regulations and relatedly how that impacted state law. That seemed to settle down, and I think many employers got their policies into compliance and had a pretty good understanding of what they could and couldn't do. Last year, of course, the legislature passed the edibles law, and now this year they passed the recreational marijuana law, which is kind of upending our understanding of workplace drug testing as it relates to cannabis and marijuana. So that's what we're going to talk about today. I understand I have about 30 minutes, and then we're going to turn it over to Don Morose, and then we'll finish with a Q&A session. I'd like to start with two caveats. One is I'm not a Teams guy. I'm more accustomed to Zoom. I can't see you. I can just see my screen. So hopefully you can hear me and see me, but I can't see you. It's kind of odd. I feel like I'm talking to myself, which is bad for a lawyer because there's nobody to bill. Secondly, this is a new law. There are many questions. Reasonable people may differ on the interpretation of the law. And so we're going to have to see what the courts do with it in some of these areas and how the courts interpret the law. I also would not be surprised if the legislature amends it over time to clarify some of the issues that are causing grief and consternation amongst employers. So with that, let's move on to the next slide. Hopefully I can do that. There we go. So the major laws we're going to discuss today, as just an overview, are the recreational marijuana statute itself, and then the Minnesota Drug and Alcohol Testing in the Workplace Act. The acronym is DATWA. DATWA is the statute that regulates employers in Minnesota who wish to conduct drug and alcohol testing. The recreational marijuana statute substantially revised and amended DATWA as it relates to cannabis testing. If we have time, we'll briefly talk about the Medical Cannabis Act. I think many are familiar with that, but the legislature, years past, has allowed certain individuals to use medical cannabis for medical reasons and enroll in a patient registry. And if you're enrolled in the registry and your employer tests you for drugs or alcohol, essentially that would constitute a valid explanation for a positive test. So nothing's really changed there. And then last year we had the Minnesota Edible Statute. And then related to all of this is something called the Lawful Consumable Products Act, which has been on the books for decades. It basically prohibits the right of an employer to discipline or take action against an employee for consuming a lawful product during non-working hours off of the employer's premises. There are some exceptions, but the question now that edibles are lawful and recreational marijuana is lawful is whether an employer can take action against an employee for consuming those products, which are now lawful, during non-working hours off of your premises. And the legislature has said, essentially, no, you cannot do so. Now, in some cases you can test, and if they fail the test, that's different. But the mere act of consuming these products during non-working hours off your premises is essentially protected conduct. You cannot discipline an employee for doing that. All right, so let's dive into the new law. The effective date for the employment protections is August 1st. There's a whole series of provisions dealing with the cannabis industry and taxation and things like that. But for employers, it appears that the workplace protections and the amendments to DATWA take place on August 1st. So it's coming up here in about a month. Under this statute, the use, possession, and transportation of certain amounts of cannabis flower and paraphernalia by adults who are 21 or older is now lawful, essentially for recreational purposes, not simply medicinal purposes, as under the medical marijuana law. And the statute redefined the definition of a drug for purposes of DATWA, the drug testing law. So a drug is now a controlled substance, but it specifically does not include marijuana, tetrahydrocannabinols, cannabis flower, cannabis products, lower potency hemp edibles, and hemp-derived consumer products. So this is sort of a technical issue, but it's a really important one because previously under DATWA, the statute authorized employers to conduct, quote, drug and alcohol testing of job applicants and employees in certain circumstances. But the definition of drugs no longer includes marijuana, cannabis, or cannabis-related products. So unless the legislature has explicitly stated you can test for those things in the new law, which they have in some cases, and we'll talk about those, you can't rely upon your old understanding, which is that you could test for drugs broadly stated. So amend your policy accordingly, and you're going to now have to talk specifically about drugs on the one hand and cannabis and related products on the other, as well as alcohol in 3 different categories, not just 2. So as I indicated, there's a new category of testing called cannabis testing for the presence of cannabis flower and cannabis products, et cetera, et cetera. And you can't do it. You can't test for cannabis unless it is explicitly permitted under the statute, which again is in some places amending DATWA. So specifically, the legislature spent a lot of time talking about when an employer may test for cannabis at the pre-employment stage. And the short answer is Minnesota employers no longer may test for cannabis at the pre-employment stage unless the applicant fits into one of 7 positions that are defined by the statute. I tried to come up with a catchy phrase last night for what these positions are. I'm calling them the 7 lucky positions. But as you see on the screen in the first bullet point, the Minnesota recreational marijuana law now says that an employer must not request or require a job applicant to undergo cannabis testing solely for the purpose of determining the presence or absence of cannabis as a condition of employment, unless otherwise required by federal, state, or federal law. So, for example, if you had a commercial driver under DOT regulations and you were required to conduct a pre-employment test under DOT, yes, you can continue to do that, notwithstanding Minnesota's law. But basically, the first bullet point indicates, in general, there's a prohibition. You cannot test for cannabis unless it's required by law, except for the 7 positions we're going to talk about in a minute. It goes on to state that unless it's otherwise required by state or federal law, you can't refuse to hire someone because they submit to a cannabis test or another test, like a drug or alcohol test, that happens to detect the presence of cannabis. So let's assume you are conducting a pre-employment test for what you believe to be the other illegal drugs like cocaine, methamphetamine, what have you, and for some reason the laboratory also tests for THC and it comes back positive. You can't look at that lab result and now refuse to hire the person because of the THC or cannabis result. As indicated in the bottom, you can, however, test at the job applicant stage certain employees who hold 7 defined positions, and those are shown on the next slide. As a footnote, at the end of the presentation, I'm going to share with Lisa from the Safety Council PDF version of these slides, and I believe she will make them available to anybody who wants a copy. So what are the 7? Go ahead.
I will send them out to everybody on the line.
Okay. So what are the 7 positions? And this is going to come up throughout the presentation, because in some circumstances, whether you are within these 7 positions will dictate whether you can be tested or not. Certainly at the pre-employment stage. So the first category is safety sensitive positions. This is a statutory definition from DATWA that has been in the law for decades. They did not change the definition of safety sensitive. So the definition is a job including supervisory or management position in which an impairment caused by drugs, alcohol, they now added, or cannabis usage would threaten the health or safety of any person. But in substance, the definition is the same as it was before. That's a whole different conversation. What types of positions could be properly classified as safety sensitive? There's some obvious ones. I think most people believe that positions involving the operation or driving of a vehicle or heavy equipment, machinery, safety sensitive, being in safety sensitive location of the workplace, like a factory floor, likely would be safety sensitive. It even includes certain management positions where, decision making and judgment could threaten the health or safety of other people if impaired. But previously, when it came to pre-employment drug and alcohol testing was not limited to people in safety sensitive positions. Under the current version of DATWA, up until August 1st, is still in effect, you could test any applicant for drugs of all types, including THC, marijuana, cannabis, what have you. But after the effective date of the law, you cannot do so unless the employee is in one of these 7 positions, the first of which is safety sensitive. And then second, we have peace officer, third, firefighters, fourth, positions requiring face-to-face care, training, education, supervision, etc., or medical assistance to children, vulnerable adults, or medical, psychiatric, or mental health patients. Fifth is a position requiring a commercial driver's license, or when state or federal law requires drug or alcohol testing of a job applicant or employee. Sixth is a position of employment that's funded by a federal grant. And finally, number 7 is any other position for which state or federal law requires you to test the job applicant for cannabis. So for these positions, the hook in the statute is that the recreational marijuana law says, although drugs in general don't include cannabis and its metabolites, if you hold one of these positions, the term drug still does include cannabis, and hence the authority you always had to test for drugs would allow you to test for cannabis with respect to someone in these 7 positions. So it's a little confusing, but at its core, you can no longer test job applicants of all types for cannabis. You can only test those who hold one of these 7 positions. All right, moving on. The statute also prohibits arbitrary and capricious cannabis testing. There was always a provision in DATWA that prohibited arbitrary and capricious drug or alcohol testing. So this is effectively not a change in the law because previously drugs included cannabis, marijuana, THC, what have you. You can enact workplace conduct rules regarding the use, possession, impairment, sale, or transfer of cannabis while the employee is working or while the employee is on your premises or operating your vehicle, machinery, equipment, etc. But this is really important. You have to do this if you want to discipline an employee for doing these things, using, possessing, being impaired by, selling, or transferring drugs in the workplace. And when it comes to cannabis and cannabis product, lower potency hemp edibles, and hemp-derived consumer products. And the reason is that the lawful consumable products statute that I mentioned earlier, which prohibits you from taking action against someone from the non-work possession or use of lawful products, including these things now, could cause you some problems. So basically they said you can adopt work rules that prohibit employees from doing these things in the workplace, and you should, because that's kind of a hook then for imposing discipline against someone who is otherwise using a lawful product. And related to that, it says the employers are not required to accommodate cannabis products. I don't know what this really adds to the statute, but in any event, there's language in the statute saying that you're not required to accommodate it, whatever that means. Okay, so related to all this, once you have adopted those policies, you can discipline or discharge or take adverse possession against the employee for, again, the use, possession, impairment, sale, or transfer of cannabis in the workplace. You could always do this for, drugs, meaning illegal controlled substances, or alcohol, and you still can. But now, if you want to do it for cannabis, you've got to have it in your policy. And for the moment, I just want people to understand, this authorizes you to essentially prohibit these behaviors and then to take action, disciplinary action, up to and including termination for the use, possession, impairment, sale, or transfer in the workplace. This provision does not, by itself, though, authorize you to test the individual. We're going to talk about that in a minute. That is to say, when can you actually conduct a test to see if they're under the influence of cannabis. So under the statute, as you can see under the sub bullet points, you can discipline, discharge, or take adverse action, number one, if as a result of consuming cannabis flower or a cannabis product, the employee does not possess the clearness of intellect and control of self that the employee otherwise would have, whatever that means, but I take it to mean they're impaired. I think that's essentially what the legislature is getting at. Next, if the authorized cannabis testing verifies the presence of cannabis following a confirmatory test. But again, this doesn't authorize you to do the test. This is just saying if someone fails a lawful cannabis test, then you could take disciplinary action against them based on that positive result. But please note that what in general prohibits employers from firing or terminating employees following a first positive test result, now including a first positive cannabis test result, unless the employer gives the employee an opportunity for an evaluation and to undergo, counseling or rehabilitation as appropriate following the evaluation. So it's kind of a 2 strikes and you're out law. After the first strike, you can't terminate an employee in Minnesota. This has been in the law for decades.
Hey,
And,
Craig, I'm going to interrupt with a question really quick because it is privy to this section. Would this also apply if an employee is operating their personal vehicle and it is work related?
Would what apply?
I think the discipline, so in machinery, equipment, premises. So if they're off, but they're in their own personal vehicle, but it's work related.
That's a great question, because the language itself says that the employer may discipline, discharge, or take adverse personnel action for cannabis use, possession, impairment, sale, or transfer while they're working. So if they were working, albeit driving a company vehicle, so let's say maybe they're a salesperson, then I think yes. But if they were not working, then you'd have to go on to see, well, were they on your premises? Under this hypothetical, presumably not, if they were operating their personal vehicle, I assume off the premises of the employer. And then it goes on to say, or operating the employer's vehicle, machinery, or equipment. But the premise of the question is that it was not the employer's vehicle, rather it was the employee's vehicle. So I think the answer is, if the employee was operating a personal vehicle, but conducting work for the employer, then you could. But if they were just operating a personal vehicle off your premises during non-working hours and somehow consuming or under the influence of cannabis, this would not authorize disciplinary action. Now, this raises an interesting question, though, because the law also talks about criminal penalties for essentially like driving under the influence, of cannabis and such. And I think to some extent that's still unlawful. So it begs the question of, if it was like a criminal activity, could the employer discipline for that? I'm not sure. Because this talks about what the employer may do. This language from the statute, it doesn't like literally say what you cannot do, if that makes sense. So I don't want to go so far as to say like absolutely positively you couldn't do it, but I will say this is a safe harbor. You clearly could discipline, discharge, or take adverse action based on the things that appear on this slide. And then the third bullet point is, as provided in your work rules for cannabis and cannabis testing, and is otherwise authorized or required by state or federal law. Third bullet point is a little bit confusing, though. Like, for example, you'll see in a minute, the reasonable suspicion testing prong of DATWA was amended, but it doesn't literally allow you to do cannabis testing if you have reasonable suspicion that the person is under the influence of cannabis at work. But it does allow, in some contexts, you to conduct reasonable suspicion testing if they violate your work rules. So I guess one of the questions is, if you prohibit the impairment at work by the use of cannabis, could you then conduct a reasonable suspicion test? I think the answer is no. You're going to see in a minute. Lisa and I had an extensive discussion about this before we started, and she tends to agree. But in any event, the lesson here is update your policy to, clearly prohibit the use, possession, impairment, sale, or transfer of cannabis while working on your premises, operating your vehicles, machinery, or equipment, because at least that will open the door as much as possible to taking disciplinary action. Okay, so let's move on to DATWA, and I'm going to focus on how the the recreational marijuana law essentially amended DATWA. But DATWA is, the state drug testing statute. It pretty much covers all workplace drug testing in the state of Minnesota. I'm putting aside DOT and federally mandated testing. That's a whole different ball of wax. We can't talk about that today. We don't have enough time. But for a private or public employer in Minnesota who is conducting drug, alcohol, or now cannabis testing because it wants to, like you've chosen to do so, not because the government, not because the federal government is telling you you must, but because you're choosing to do it, you fall under DATWA. And there's, basic requirements, including having a policy. You can only test under certain circumstances, which we'll go through, and you have to follow certain safeguards and reliability standards. Okay. You have to have a written policy. You always did under DATWA. You still do. You've got to amend the policy now if you want to do cannabis testing, because the statute says you may not test for drugs, cannabis, or alcohol unless it is stated in your policy. And you have to have other information as indicated in the slide. But due to time limitations, I'm not going to go through each bullet point. Just be aware you need to beef up these policies and do it before August 1st. All right. You also have notice requirements. You have to notify all affected employees upon adoption of the policy. If someone moves into a position that was not affected before, but now they're going to be tested, you have to notify them at that time. And you have to notify a job applicant before you test them of your policy. You also have to post a notice in a conspicuous location. That notice in your break room or whatnot, and I hope you would now post it online as well for employees, has got to be specific that you're now going to be conducting cannabis testing, if in fact that's what you want to do. Okay, what are the permissible tests? These are categories that were always in the law. We're going to walk through them, and I'll tell you how the recreational marijuana law has impacted these various categories. So the first is job applicant, or commonly called pre-employment testing. So the first part says that an employer may request or require job applicants to undergo drug or alcohol testing, and that if they have received a conditional offer of employment, and the same test is required of all applicants who have conditionally been offered the same position. That's always been in the law. But remember, the definition of drug no longer includes cannabis, so you cannot conduct cannabis testing for job applicants in general, except for those 7 lucky positions. Why? Because the legislature has created an exception saying if you're in one of the 7 lucky positions, then cannabis is now still considered a drug. So we already talked about this before. So pre-employment has been changed substantially. The legislature has very narrowly limited the positions you can test at the pre-employment stage. If you do withdraw the job offer, you have to inform the applicant of the reason. So routine physical examination testing was a category under DATWA that was always recognized. So you could request or require an employee to undergo drug or alcohol testing as part of a routine physical exam once a year. You had to give them 2 weeks written notice. Under the recreational marijuana law, though, this is limited to people in the 7 lucky positions, whereas previously you could test any employee who is undergoing a routine physical exam. What about random testing? There's essentially no change here. They have said that an employer may request drug, alcohol, or cannabis testing if the person is in a safety sensitive position that's been the law for decades, or they're a professional athlete. The definition of safety sensitive we talked about earlier, it's on the bottom of the screen, same definition I read earlier. So really there is no change here, but I will note that for cannabis testing done on a random basis, it is only the safety sensitive workers who are on the list of 7. It's not everybody. So like for example, the other categories like police officers, firefighters, medical personnel, CDL holders, federal grant employees, etc., are not literally, you're not literally allowed to do random testing for all of those. However, I would think that many of them could be classified as safety sensitive. So just don't misunderstand what I'm saying. I'm not saying, for example, you can't test a peace officer, but you your reason for testing them on a random basis wouldn't be subdivision 2. It would be because you're going to make an argument that the peace officer is a safety sensitive position. Same with the firefighter, same with the medical personnel. So that's an area of ambiguity under this law. The courts are going to have to sort out which of those 7 lucky positions are safety sensitive for purposes of random testing.
So with
Okay, what
those
about-
7 positions, Craig, I have a question and they want to know, does that mean they can deny employment to a firefighter if they test positive pre-screen?
Yes,
Thank you.
because a firefighter is one of the 7 positions. You're allowed to do a pre-employment test for the 7 lucky positions. And if they fail, you can withdraw the job offer.
Okay, then next question, for safety sensitive position, is that only management and supervisors? How about service technicians going to a job to make repairs, operators, heavy machinery? I would deem that safety sensitive, but I'll leave that up to you to answer.
I think probably it is. It's certainly not limited to management personnel. I think if anything, the legislature wanted to make it clear that persons that you might not think of as safety sensitive because they're not operating equipment, machinery, vehicles, but are in a management position where their, judgment can affect the safety of others. Those are in some cases safety sensitive. But clearly, I think your, factory worker in a safety sensitive setting with heavy equipment, machinery, vehicles, a dangerous work setting, the vehicle workers, forklift operators, those folks are all probably going to be safety sensitive. Okay, so reasonable suspicion testing. This is, I think, the most controversial thing I'm going to say today, and the part of the statute that I think is the most vexing, confusing, and makes no sense. So you just got to break down the language, and it is what it is, and it says what it says. So it says for reasonable suspicion testing under subdivision 5, an employer may request or require an employee to undergo, it used to say drug or alcohol testing, it still does, but now they've added cannabis in the following circumstances. 1, if the employee is under the influence of drugs or alcohol. So here's the problem. It doesn't say under the influence of drugs, cannabis, or alcohol. So my reading of the statute, which I think Lisa has agreed with, is that you could not do reasonable suspicion testing of an employee if you simply believe they're impaired at work for cannabis, unless they're in one of the 7 lucky positions. And the reason is, for the 7 lucky positions, cannabis is still considered a drug, but for everybody else, it's not. And so because this language says you're allowed to do it only under prong 1 if they're under the influence of drugs or alcohol, if you have someone who's not in the 7 lucky positions, let's just take the receptionist, clearly not safety sensitive, not a police officer, not a firefighter. If they're under the influence of cannabis at work, and perhaps they even admit it, like I was smoking weed in my apartment last night off your premises during non-working hours, and I'm high, I don't think you can test them.
Mm-mm.
You could discipline them and even fire them for being under the influence at work if your policy so provides, but I don't think you can test them. Second, it says if the employee has violated your written work rules prohibiting the use, possession, sale, transfer of drugs, alcohol, and then now it includes cannabis. And you would say, but wait a minute, Craig, you just told me, doesn't that authorize you then to test the person if you think they're under the influence of cannabis at work? And I would ask you to reread number 2. It doesn't say under the influence. It said using it at work, possessing it at work, selling it at work, or transferring it at work. So if they're using, possessing, selling, or transferring cannabis at work, then yes, under prong 2, you can test them. But when it comes to being under the influence of cannabis, I think you're stuck only conducting testing on a reasonable suspicion basis if they are in one of the 7 lucky positions. All right.
Craig, I have one question and it's a big one. What about employees that work from home?
What about them?
So I think they're wondering about testing. Is that considered on the premise? If they're
Well, it
home
says
office?
under prong 2, it's prong 2, it says using, possessing, selling, or transferring, quote, while working. So it's not tied to the premises. So whether or not you consider their home office, let's say, to be the employer's work premises, the fact that they're working would allow you to conduct testing if you had reasonable suspicion they are using or possessing, selling, or transferring, if that answers the question. Under prong one, it doesn't talk about, frankly, believe it or not, it doesn't even talk about bound to working or under your premises or equipment or anything else. It just, if you think they're under the influence. I think employers have always interpreted prong one, as I have, to mean under the influence while working. But so does that answer the question? I hope it does, but we're gonna have to keep bracing through this because we're gonna run out of time. All right, so reasonable suspicion testing under the statute also breaks apart separately what I would call post-injury and post-accident testing. So it goes on to say that an employer may also request or require cannabis, ding, 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 or drug and alcohol testing if you have reasonable suspicion that they've sustained a personal injury under the Workers' Comp Act or caused another employee to do so, or have caused a work-related accident. So here, it's not limited to the 7 lucky positions because you're simply allowed to conduct cannabis testing of any employee, as well as drug and alcohol testing, if they have sustained a personal injury or caused a work-related accident. And you may say, Craig, why do you have it, heading 3 and 4? Shouldn't that be 1 and 2? The reason is it's really a continuation of this slide, but conceptually, most employers think of reasonable suspicion testing being, I think you're under the influence or you violated my workplace rules regarding drugs and alcohol, whereas they, at least based on kind of the way DOT defines it, think of post-injury and post-accident testing as a separate category. So I've kind of split it up that way. Okay, what about treatment program testing? You can test employees, including cannabis testing, if they've been referred by you, the employer, for substance abuse disorder treatment or evaluation, or are participating under your benefit plan. Then you can test them during the period of evaluation and treatment if treatment has been prescribed, and up to 2 years following the conclusion of the treatment program. This is really no change from the law. It's very important in your policy that you include a provision authorizing treatment program testing. And the reason is because of the 2 strikes and you're out rule, that is, you can't fire after a first positive typically. What you want to do then is to refer the person, whether they fail a cannabis test, alcohol test, or drug test, to an evaluation. And then if the chemical addiction counselor, what have you, has recommended some type of treatment, education, counseling, what have you, you can then test them for up to 2 years after that. So this is really not a change in the law, and it's not limited to the 7 lucky positions. This is any employee who has been so referred or is participating under your benefit plan. There's a bunch of procedural requirements under DATWA, like acknowledgement forms, the use of certified laboratories, chain of custody. You can't require the employee to pay for the test unless they request what's called a confirmatory test, but none of this has really changed. There's notification requirements following a negative and positive test. Again, we're running out of time, so I'm not going to go through all of those. But we've done seminars in years past where we went through all of the nuts and bolts, all of the minutia of DATWA, and covered all of these technical requirements. So I think that's something we're going to cover during future sessions where we've reserved more time. But again, the statute itself has a gazillion procedural protections and rights that employees have, and notification obligations on you as an employer. But today, we have covered the ways in which the recreational marijuana law has changed DATWA, primarily by narrowing the circumstances under which you can test for cannabis. And that's the primary change. Nothing's really changed in the Minnesota Medical Cannabis Act. We talked about that before, but basically the gist of it is you can't, as an employer, take action against someone who's in the Minnesota Medical marijuana or cannabis registry, or who test positive because they were lawfully using medical cannabis. So essentially that's an explained positive test result under bullet point 2. It's not a change from the law that's been around since the legislature adopted the medical marijuana law. The edible statute, it was kind of confusing, but the takeaway from the edible statute is that the legislature last year, when they passed the edible statute, didn't really say whether the edibles are now considered a lawful consumable product under that lawful consumable product statute, because they're still unlawful at the federal level. And they now, the legislature has clarified that. So under the Minnesota lawful consumable products statute, it's clear now that these edibles, as well as essentially the recreational marijuana, is considered a lawful product, and hence you cannot, in most cases, discipline or terminate someone for consuming those products during non-working hours off of your premises. And that was the last slide here. The main change is on the bottom of this slide, that the recreational marijuana law now explicitly includes cannabis flower, pot products, and low potency hemp edibles and hemp derived consumer products as a lawful product. And again, you can't discipline or terminate someone for the off-duty consumption of those products. You can for the on-duty consumption. That's never been limited. And there are some exceptions for if it's a bona fide occupational requirement or the employee's use would create a conflict of interest. So there are some exceptions under the lawful consumable products law. I don't know how that would play out with the recreational marijuana, but classically, for example, if you were operating an addiction clinic, you could prohibit, let's say, your counselors from drinking alcohol if they're like a recovered alcoholic, because that would create a potential conflict of interest if they were drinking outside of work while they're trying to counsel your patients in your clinic. So that might have fit under either the bona fide occupational requirement exception or the creation of a conflict of interest. So we covered a lot today. I'm sorry that we didn't have more time, but if we have a little bit of extra time at the end after Don presents his talk, I'm happy to answer questions. Again, get a copy of the slides from Lisa. Feel free to reach out to me if you by email if you have questions, and I'll try to do my best to help you. We are obviously furiously working to update employer drug testing policies in light of the new law. And so with that, I'm going to hand it back to Lisa.
Thank you so much. Questions are coming in and I'm answering them as quickly as I can, and we will be taking more questions at the end of the webinar. We are going to switch gears right now and move over to Don Moroz, who will be talking about reasonable suspicion. And as Craig alluded to, there are some classes that have been previously scheduled that will be delving into these two issues much, much more deeply, and we're allowing the appropriate amount of time to really get into the weeds. This webinar was to scratch the surface because there's so many questions out there right away. So with that, we're going to get right into reasonable suspicion. And Don, I'm imagining you need to be able to share your screen. There you go.
There it is. There it is. Okay, we're you see it?
I do not.
Okay. Let me try again.
I do now. It's up.
Oh, but you know what? I forgot to. I better forgot to do the sound. So I always forget to do
Okay.
the sound quick. So let me just do that quick.
Not
Apologies.
a problem.
All right. Let me know when you see it.
Okay. It's up. Good to go. Thank you so much.
All right, folks. Thanks so much for having me today. As both Lisa and Craig said, my name is Don Moroz. I spent 32 years on the Minnesota State Patrol, 27 years on the Metro Transit Police, retired from both of those professions a couple of years ago, but spent the entirety of my career training police officers on how to better detect impaired drivers. So I come from that impaired driving background, but the signs and symptoms aren't any different. If somebody's going to work, going to school, whatever it happens to be, driving a car, impaired, the signs and symptoms are the same for the stuff that they're using. So for about 15 years or so, have been bringing this message out to businesses and schools and the public and essentially anybody that'll listen to me. So some of you, I suspect I have met before. I didn't scroll through the entirety of the attendee list. So for those of you that haven't met, nice to meet you. And for those that have, great to see you again, even though we are not face to face. So, and let me just kind of lead on. And I was trying to keep up with the questions as well. And holy cow, as somebody that read laws and dealt with laws from the enforcement side for a lot of years, holy cow, Craig. I don't know how you do it, how you keep up with it as fast as things change. And now I read through this, and the version I got, the conference committee version, was about 300 pages long. So I waded through that 2 or 3 times trying to get my arms around it. So hopefully I've got everything nailed here. And I think I had until we had the discussion this morning. And I don't want to put words into Craig's mouth, but that one reasonable suspicion piece that it says cannabis testing, but then it says only test for drugs and alcohol. I think we all three, Lisa, Craig, and I agreed that was an oversight by the legislature. They should have put cannabis testing into that number 1, parens 1 as part of that drug, alcohol, cannabis testing. That is my guess. So all those questions about what do you mean you can't test for cannabis now, I think that was an oversight. So just hearing that this morning, I think all 3 of us are probably going to work our networks to try to figure out if that needs to be fixed, hopefully sooner than later. That being said, that is what the law says. So letter of the law versus spirit of the law, we certainly all understand those as well. I will try to talk a little bit about from the reasonable suspicion impairment side of this. Ton of testing questions came in. So I will try to address some of that too, as far as the test itself. So when we talk about cannabis, different various forms here, we call it all kinds of different things now. As you saw in Craig's little snapshots of the statutes. So cannabis and edibles and low potency edibles and synthetic cannabinoids. And I actually put into my slide here the quote artificially derived cannabinoids. All that being said, I am just going to say cannabis, quote unquote, today to cover all those. In fact, I think a couple of my slides say cannabis, comma, etc., catching all those things. So not to overwhelm you with, a dozen different terms that the legislature has determined what those are. Generally speaking, we're talking about pretty much all derivatives, concentrates, synthetics, artificially derived, whatever it happens to be, pretty well. I think they did a pretty good job of catching everything that's out there through definition. So we will just kind of call that cannabis today to talk about that. So as we have known, actually, let me start that statement over. If you had asked me 5 years ago when I was still on the job, what do we know about cannabis? And I would have probably said something like everything. Essentially everything. We know how it's done. We know what the active ingredient is. It gets you high. We know that the the left side of the house, the impairment side of the house, that's the THC side. The allegedly non-impairing side of the house, the CBD side. So it's THC and CBD, and that's it. And this is how they derive stuff. And we pretty much know everything. Now I'm almost to the point like we don't know nothing. Because just in the last couple of years, we've heard about Delta 8, Delta 10, and HHC, and THCO, and THCA, and Delta 6, and all kinds of different stuff on the impairing side. And then we've heard about CBG, and CBN, and CBR, and different things on the CBD side of the house, and all kinds of new stuff, so to speak, that are coming every day. And science is pretty good. And science is good regardless of what part of science we use it, and wherever you land on the should we have recreational or not, you probably have a pretty good feeling where I land, but doesn't matter to me. It's kind of the impairment in the workplace that we're going to talk about today. So when I on the slide here I say primarily Delta 9, it still is primarily Delta 9, but I would think in the next year or so, I'm going to have to water this slide down a little bit and go, yeah, probably this and some other things, but all kinds of stuff that is out there on both sides of the fence now. So we have heard that cannabis has been around for hundreds and thousands of years, and people have been using it as medicine, recreational, whatever it happens to be. You've all heard those statements. But it wasn't until 1964 that science kind of figured out what is the substance that's in cannabis that gets you high. And they identified THC. So that was the Delta 9 stuff. So again, for the last roughly 60 years here, we have said, yep, it's Delta 9 THC. But it wasn't until 1988 that we actually identified those cannabinoid receptors in the brain, the parts of the brain where the stuff on Delta 9 sticks to and it affects and makes things happen in the brain that gets you high. So really, that's only for the last 35-ish years we have known how it works. So again, science is great, but you can just see in here a difference of about 25 years between we figured out the substance that gets you high. It took us 25 years to figure out why that substance gets you high. Now, science is better, so it doesn't take us as long to find those things. But as you can see, things have really changed quite a bit, just like I said, in the last handful of years, if not even less than that. So I took while Craig was talking, I knocked my workplace slides out of here because he kind of covered those in depth, and we'll try to answer questions as far as that goes near the end here as well. So I'm just going to talk about the new cannabis law kind of in general. So other things besides workplace. So can we set rules for, possession? Sure, we can. You can't possess alcohol. That's a legal substance, in the workplace. You can't possess cannabis in the workplace. So this is the law for, not specific to workplace. This is what the law will say now about recreational cannabis and individuals in Minnesota. Got to be 21. I think Craig mentioned that. Paraphernalia is no longer illegal. And I talk in my reasonable suspicion class a lot. What if you see paraphernalia? What if you find paraphernalia? Can that maybe make you go, I wonder if this guy might be under the influence? Absolutely. So again, even though it's not illegal, we can still look at that and go, why would you carry a marijuana pipe at work if you're not using a marijuana pipe at work? Might make you scratch your head. Now, again, not a guarantee that that person is under the influence, but it might make you just go, and that's one of my catchphrases I'll mention a little bit more in a few minutes here. You can possess up to 2 ounces of flower. That is the chopped, dried up version of the leaves. You roll in a joint, put in a one hitter, put in a pipe, whatever it happens to be, what we typically know as marijuana. So 2 ounces of flower in a public place, possession. 2 pounds of flower in your private residence. 8 grams of concentrates. And again, that's a lot of stuff that we are fairly new things that we've been talking about. It used to be hash and hash oil for decades and decades. Well, now it's butter and wax and shatter and butane honey oil and a million different things that are out there. But 8 grams, that's actually quite a bit of concentrate. And the big deal with that, at least from where I stand, is those concentrates can be up to 100% THC. So 8 grams is a ton, comparatively speaking, with some of the other stuff. Then 8 milligrams of hemp edibles, and those are the allegedly non-impairing stuff that is either derived from CBD or is made of CBD, and those rest of those things on that side of the house. So you can have up to 800 milligrams of those. Now, use. This is an interesting one. Again, got to be 21 years of age to use. The edible law is, as Craig mentioned, a lot of those things got fixed in the new law here. One of the things on the current edible law still today, up until August 1st here, is there is no violation, no issue if somebody is under 18 or under 21 and possesses, and there is no provision for providing, kind of like alcohol. Got to be 21 to buy it, got to be 21 to possess it. If I'm 21 and give it to somebody, sell it, whatever, to somebody under 21, that's a violation for me. That's not what the current edible law says. That, again, that will change here in about a month. So currently, right now, I can go in as a over 21-year-old, buy a baggie of edibles, turn to the 14-year-old kid next to me, hand it to him, and go, knock yourself out, kid, have fun. The clerk who sold it to me didn't violate anything because he sold it to somebody who was over 21. I didn't violate because there's no providing, and the 14-year-old kid walking around with it is not in violation, being under 21, because that is not in there. So a bunch of loopholes in the current law. And again, that's been on the books for about a year. Well, a year this weekend, on July 1st of last year, that has been fixed. Most of that has been fixed by the new law. So you can see use is 21 across the board here. So use in your private residence, which includes your yard, garage, anything that is on your private property. You can use on private property that might not be yours. So if you are renting a home or that type of thing, unless the owner prohibits. So the owner might say, hey, no use in my rental, no use in my apartment building, whatever. They can do that. kind of like with smoking, we can have smoking areas outside, that type of thing, but they can limit what can be done for use in their private property. Then add a business that is licensed for on-site consumption. So again, think of a bar. I can consume alcohol in the bar. I can't walk down the street with it. I can't walk out the door with it, but I can consume it on that business premises. So there will be licensed businesses now where you can go purchase edibles, purchase smokable, whatever it happens to be, version that they are selling. There's some restrictions there I won't get into, but they can sell it to you on the site. You can use it there as long as they are licensed for that on-site consumption. So you will see on here, it does not say in public. And that was one of the things that I scoured through the law 2 or 3 times. And I am more than willing for somebody to say, hey, you missed it. It's on this page or in this subdivision. But boy, I looked through it 2 or 3 times, and I've heard a couple other people say there's no provision there for use in public. It's just all in kind of private property stuff that you see here. So cannot use in public, cannot be used where it may be inhaled by a minor. So we can't use it in an area where kids might have be exposed to it, for lack of a better term, and then no use in a motor vehicle. So kind of like open bottle. So we can't consume alcohol while we are driving. We can't consume any of these cannabis, etc. products while we are driving that motor vehicle. So open package in a motor vehicle, again, kind of like open container of alcohol. That vehicle's got to be on a street or highway. So again, if I am on private property, I'm in my driveway, and I have an open container in my driveway, that's not a violation. So it's got to be on a street or highway, a public roadway. Must be, if it is in the vehicle, it's got to be in the original or approved packaging. And there's a whole different set of subdivisions on what is approved packaging. Essentially, I can't go buy some, bust it open, shake it into a Ziploc bag, you throw it in my car and say, hey, I'm carrying it, but I'm not using it in my car. You can't have it. Once the seal has been broken of that original or that approved packaging, and approved isn't, hey, can I call up and get my packaging approved? Approved's got to be from kind of that manufacturer and or seller individual on how that is, how that packaging is approved. So big thing in here is that the seal can't be broken. So just like alcohol, on a quote unquote party bus, we can use it those in a limousine. And interestingly, I think they kind of copied and pasted the open container language from alcohol, and they put it in here for open package in a motor vehicle. And it says, for lack of a better term, a pedal pub. They have a whole longer definition of or description of what that is. But if you've ever seen the rolling bars with a half a dozen people pedaling the bar around a downtown area, it can be used there, which then begs the question, what isn't that in public then? So again, a little, I think, misstep on their part. I think they copied one part of the law and didn't consider what how those two things coincide with each other. That happens every time a law gets written, and folks like us and Craig and Lisa, we flag those things, and questions from you help us flag those things, and then we go back and go, oops, we missed this up. We kind of screwed something up here. We got to fix this. So the owner is liable for that open container, or the driver. So just like with an open container, and I'll use alcohol as the example again here. If I'm the driver of the vehicle, my passenger has an open container, I am liable for that, which means it is a violation for me as the driver to allow that, or the owner of the vehicle to allow that. So my buddy gets a citation for an open can of beer, I get the citation for allowing. So that can happen. Same thing here. And again, doesn't apply to the trunk. So if I have that open container, but I throw it in the trunk of my car, I'm good there. So same thing. I have an open bottle of wine, it's corked, and it is secured in the trunk of my vehicle. That does not constitute open container. So a lot of questions on drug testing. So I want to get to that. Not testing on can we do it, more how testing kind of works. And there was a ton of questions. I'm not tracking them right now, so I suspect there might be a few more in there about testing. So let me just give a broad overview statement of testing in marijuana here. I suspect that most of you, probably all of you, at some point have heard marijuana stays in your system for ... 2 weeks, a month. I actually just read an article last week. It was 103 days And they were reasonably sure that this individual had zero access to any cannabis in that time. I think he was either incarcerated or in a health facility or something where, like, there's no way he really could have gotten any cannabis. And at 103 days, he was still testing positive for THC. So 3 months, a little over 3 months now, we have that as possibly the longest that we have seen, at least thus far. Now, here's the deal on marijuana testing. And whenever I hear those statements, I'm like, you got to tell the rest of the story. Well, it's not to the advantage of the individuals who wanted to legalize recreational marijuana to tell the full story. So we've heard, hey, you can't do workplace testing. You can't do DWIs because marijuana stays in your system for a month. The active THC, the stuff that gets you high, will be in your system. And I'm going to just throw a general number here because it depends on how often you use and how much you use and the potency, etc. 5-6 hours. So if I smoked marijuana at 8 o'clock this morning, by roughly 2 o'clock this afternoon, and again, it's not the same for everybody because we can't track that burn off like we do for alcohol, but roughly by 2 o'clock this afternoon, you will not find the active THC, the stuff that gets me high. Now, you will absolutely find the inactive THC, the stuff that doesn't get me high. That's the stuff that will potentially stay in my system for, and I'll just keep saying a month, whatever that number happens to be for that individual. And unfortunately, testing today, and testing is phenomenal. It has come a long way in the last couple of decades, but I think personally, I think it needs to make a few more strides, and I hope that we get there. Again, science is pretty good. The stuff that comes back positive after that use period, after that 5 or 6 hour period, is that inactive THC that doesn't get me high. And urine testing today only tests for the inactive byproduct. Okay, so I had this question just recently. In fact, I was at the Safety Council conference today presentation. Somebody came up afterwards and said, okay, here's the question. I got a guy that smokes on Friday, off work, at home, sitting around the fire in his backyard, smokes on Friday, legitimately doesn't smoke the rest of the weekend, uses it recreationally, legally, after August 1st, comes in Monday. We have to test for whatever reason. Will that person come back positive for THC? And the short answer is, yep, they will. Yes, they will. And again, if that was the only time they'd ever used in their life, it might, even the inactive might not be there, but we'll just kind of use a generic term of a marijuana user. Will they test positive on Monday? Absolutely. Will they be high on Monday? Absolutely not. Okay, so there's the problem when we talk about testing, kind of the limitations that I'm not going to go through all these, but when we talk about limitations of testing. I come in today, you and I, after incident, whatever it happens to be, with respect to the things that Craig said, you test me. I come back positive for THC after August 1st. You can't necessarily go, aha, because I legitimately may have used it yesterday. And I am not under the influence. I won't come back for that active stuff. But when we talk about reasonable suspicion, if you've got the signs and symptoms, you've got the indicators that I'll talk about here in just a couple of minutes, and we add the test to it. Now those two things work in concert with each other, and that really strengthens our base when we talk about that. So if we just pull somebody for a test and it comes back positive for THC, you got to kind of go, is it? Now, a confirmation test, typically a blood test at a clinic, at a hospital, whatever it happens to be, whatever your testing method is, if it is a blood test, that one will absolutely say, this is the active THC, this is the non-active THC. It will come back with both, if they're both in there. So if I smoke at 8 o'clock in the morning, after incident, I crash, something happens, incident at work, whatever it happens to be, somebody gets hurt, whatever, you take me in for the urine test, I come back hot for THC. You can't automatically go, aha, now, but I go to the clinic and I come back with a confirmation on a blood test in a couple of days, generally a couple of days to get that result back. And it comes back with the metabolite, the byproduct that gets you high. Now, in my opinion, you can say, aha. Okay, because now you say, well, it was in your system. The active stuff that makes you high was in your system shortly after the incident. So you clearly used it a short time before that, 5-6 hours, whatever that happens to be. You were on, you were under the influence based on the active THC being in your system. So that's where the problem's going to be with testing. Now, I am nowhere smart enough to figure out if we will ever get there. I did ask some folks that are smart enough, at least on that part of it, that actually work at the crime lab in St. Paul. I saw them a couple weeks ago and said, will we ever get there? And they went, oh, I don't know. They said, I don't, they even said, not really sure. I am confident that if there is a way to find that out, we will figure that out. It won't take decades, hopefully. Science, again, is pretty smart. $1 million idea. If you're smart enough to figure that out, go ahead and run with it. You'll probably make $1 million selling drug testing kits to all the other businesses in the world. But if drug testing can find a way to look for that in urine, I think that will be a boon for workplace. But where it is right now, it isn't. So there's a big, big gap there. That was the same thing for me when I was on the job. If I arrested somebody for DWI and took a urine test, it'd be like, yeah, we don't know. If I took a blood test, yeah, we know. Okay, I mean, that's the kind of the short way to describe that. So we talk about those cutoffs. Research suggests that there is no cutoff, and there's a bunch of research, and you've probably heard the 5 nanogram maybe. Well, this state, Colorado, sets 5 nanograms as a permissible inference for DWI. Yeah, and I mean, there is a little research, and the one they used, it wasn't research about a cutoff level. It was research about impairment, and the individuals that were part of the research project were impaired, and they were all over 5. So the legislature said, well, all those people were impaired and they were all over 5 nanograms, so 5 nanograms must be the number. That wasn't the research at all. And I chuckle a little that, a bunch of legislators got in the back room, shook some dice and went, 5? Sure, that works. So we'll call it 5. And actually, Colorado is starting to try to back off that a little bit. They're trying to change their law to take that 5 nanogram out. So there's a couple of different research, in fact, one from the National Safety Council over the last handful of years that says there is no number. Now, the more research, the better science gets. If the feds allow more research with cannabis, that's kind of one of the hangups now. Hard to research an illegal substance. It's not allowed by federal regs. If we get to that point, again, I think science is smart enough that we will get there eventually. So when we talk about an individual who smokes marijuana, typically they are about the highest while they are smoking. And then that one metabolite that I mentioned before, in pretty fast, out fairly quickly. The bulk of it is out fairly quickly. But again, this says will decline rapidly over 3 hours. Again, that's when they will tell you that they probably feel high, but that doesn't mean that active THC is gone. Again, that will last that maybe 5 or 6 hour range. But an individual, if I smoked at 8 o'clock this morning, by noon, I'd say, 11 or noon, I'd say, yeah, I don't feel it anymore. Although you could still find it in my blood probably for a couple of more hours. So let me skip that. So the blood and urine aren't impaired. The brain is. So again, when we talk about testing, testing's great, and I'm not knocking testing, but we found it in your blood. And it's like, well, if it's in your blood, then it's in your brain, and your brain is really what's impaired. So when we talk, I'm going to skip that one here. When we talk about workplace safety, really, what's our goal of reasonable suspicion testing? And we could distill it down to those last 2 words, no pun intended, but workplace safety. We need to put it in the same silo as eye protection and ear protection and hazmat training and confined space training and first aid teams and all the stuff that we do as businesses for workplace safety. We need to drop reasonable suspicion in that same silo. It shouldn't be over in a different one, like, oh, it's over there somewhere. Here's all our safety stuff. Reasonable suspicion's over there. Nope, it's got to go right in the same group with us here.
You have to switch the screen down. We're not seeing the video. There we go. Thank you.
Okay.
It's on.
Okay, that was out of Colorado, one of their ad campaigns when they legalized, which personally I thought, hey, let's go after the folks. Let's talk to them directly. So if you didn't pick up the first part of that, you just kept hitting the button to click, 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 because the steak wasn't cooking, click, 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 and then you finally realize, oh, wait a second, I don't have any propane. So again, can I use it? Can I use it recreationally? Can I get the impairment off duty on the weekend, a quote unquote weekend user, which sometimes that gets a little dicey when we start talking about workplace as well. what is the weekend? When do I start work? Those types of things. But yeah, we can do that kind of thing now. But bottom line, I mean, kind of the short answer from the workplace is can't come to work high. Yeah, just like alcohol, you can use it all you want. Can't come to work drunk, right? For lack of a better term, kind of quote unquote drunk or quote unquote high here. So kind of the same message that we need to pass along. So let me skip that one. I'll skip that one here. So when we talk about impairment, we need to think of it two ways, both physically and cognitively. And a lot of times it's the physical impairment, and that's easy. Somebody's falling, they're crashing into stuff, they're tripping, they're swaying while they walk, and etc. All those things. Easy to recognize, easy to describe. But we also have to think about that cognitive side as well. Is their brain processing the information it needs to process? A lot of times the cognitive does drive the physical. I get that, but not always. And let's not wait until there is some physical impairment. If we see something that we think, what's going on here? There's a reason that you're not processing the steps and that we have to take. I'm on the production line. I get my piece of material. I have to do 4 things to it before I send it down the line. I'm only doing 3 of them. Or I can't get my brain to tell my body to do the 4 things I need to do in the time I'm allotted before I send it down the line to the next step. Those are things where I might not be quote unquote falling down drunk, but I am equally as impaired and it's equally as dangerous. So as I mentioned before, one of my catchphrases is reasonable suspicion is as little as, that seems weird. I've never seen Don do that, look like that, act like that, walk like that, talk like that, whatever. And it's great for you folks when you have that level of knowledge. You know that individual. When I was on the job, I had to work in generalities. Most people don't do this, act like this, walk like this, etc. You know specifically, Don's been working here 3 years. He's never done that before, never seen those things before. That holds a lot more weight for you. But when I talk about what reasonable suspicion is, it is that little. It doesn't have, it is a suspicion, okay? Based on some facts, but it is a suspicion. It is not proof. Okay, but we got to remove that person from their potentially dangerous workplace, whatever it happens to be, off their equipment, machinery, off the production line before something bad happens, and try to figure out what it is. Can people be impaired on things other than alcohol and drugs? Sure. And cannabis? Sure. Lack of sleep. I can be ill. It can be medical. It can be all kinds of different things. But let's figure out what that is. And if that's what it is, then we give them whatever help they need. We get them some medical help. We maybe tell them to go home because, hey, I only slept 2 hours last night. I got a sick kid. Maybe you should go home and take a nap then because what you're doing today is putting us at risk. So this is our solution. Maybe it's the alcohol and drug route that we need to go. Let me skip that one for you. So when we talk about folks in the workplace, from the time all of us, our feet hit the floor in the morning, till the time we go back to bed, we're dividing our attention between mental and physical tasks. We talked about that mental and physical impairment. We all have to do something, sometimes more mental than physical. So depending on what your job duties are or what the job duties of your employees are, it can vary, and it can vary during the day. More mental part of my job, and then I do a more physical part, etc. From a 30,000-foot view, do we all have to process information and judgment and decision making and reaction time and coordination and balance and all the things on this list plus a bunch more? Sure. From a 30-foot view, though, you know exactly what your employees need to do to process information and their reaction time and their judgment and their decision making. When you start to see those things fall by the wayside, that is potentially impairment. Ought to make you go, that's weird. Let's before something bad happens, let's get them away from their piece of equipment and try to figure out what's going on here. So some of the things on this list cognitive, some of those things on this list more physical. So when we talk about executive function, what is that? That's the part of our brain that deals with these things. Divided attention, like I just mentioned. I'll let you read the list here. So executive function is our ability to plan, to make decisions, to understand, to process information. I'm driving a car, kid runs out in front of me. My brain goes through 1,000 different calculations in a fraction of a second to decide what I need to do to steer, brake, whatever, to keep from hitting that kid that ran out in front of me. That is all part of executive function, that part of your brain. So what does cannabis and an executive function do? Again, affects our divided attention, our concentration, our decision making. And again, I'll let you read the list here. But it's those things. Cannabis has a direct effect on an individual's executive function, the part of their brain that does the stuff that we do, again, all day, particularly at work. Particularly, I suspect, in most of your industries, deal with all of these types of things all day long. Your employees do these things all day long.
This car has been stopped for quite some time. I'm going to check it out.
Is the video showing?
It is
This
not
car's been
showing
stopped
yet.
for quite some
You might want to
Okay.
turn off your camera.
Okay. Let me try to do that. There we go. All right, let me get back into my share here. Let me know if it pops up there. If it doesn't, I'll skip through this.
It's on, but with no volume.
All right. Well, we're up against the wall on time, so we'll skip that. It's a humorous video. I can send it to you or reach out and I can get it to you otherwise. So what are some of those indicators of impairment that might do us that somebody is high at work if they smell like it? But the caveat to there is edibles, obviously no smell. Some of those concentrates that we've talked about, the things that they do to extract THC. If somebody vapes that stuff, quite honestly, you could almost be standing next to them, and this is about as confident as you'll be. That kind of smells sort of like somebody might be smoking marijuana somewhere, and they might be standing right next to us. Now, if I'm smoking flower, the dried up, chopped up version of the plant, we've all probably had this. You can get that from 200 yards away. You know, heck, I've smelled it on the freeway from the car in front of me, and I suspect that a lot of you have as well. So, depending on how they consume, that's not always a thing. We talked about their perception of time and distance and the kind of that reddening of the eye, some body tremors, some relaxed inhibitions. They're laid back. They don't care what's going on around them. They're chuckling when you don't think that they should. The situation doesn't really warrant that type of thing. You know, we laugh about the munchies as being a stereotype for that quote unquote stoner. It's an actual deal. You know, all those things that we see on that stereotypical stoner that we see from an entertainment perspective, a pop culture reference, those things are all done. Now, we do those things for entertainment, but those things are all legit. One of the things that we'll also do is dilate their pupils when we talk about that. All right, so let's talk real quickly, a little scenario here. So Kathleen works in your IT department. She's a relatively new addition, usually reliable, punctual, comes in on time, no issues there. Everybody's happy. Your customers are happy. Your coworkers are happy that she does what she needs to do. But you do start to notice that she goes to her car on every break, lunch break, couple of coffee breaks, 3-4 times a day, whatever that happens to be. She goes out to her car. You think, well, that seems a little weird. Well, whatever. But is that alone anything? Of course not. But when she comes back, she's a little more jovial and outgoing and telling jokes and laughing. Carefree attitude usually lasts a few hours and then comes back after the next break. Cubicle is always dark, and people are always asking, geez, how do you see what's going on here? And she uses eye drops a lot. Then she just says she's got a lot of allergies. Now, any one of those things, one of my other catchphrases is there's no silver bullet, no one thing that means one thing, but we start to add this stuff together. She's going out to her car, which seems kind of interesting, comes back, her attitude's different, starts to fade after a few hours, like we talked about, they're high for a few, quote unquote, for a few hours, and the teams pop back up again after the next break. Cubicle's dark. Why? Her pupils are dilated, can't stand the light, so she turns everything down. She's using eye drops to try to maybe diminish the redness of those eyes. So any one of those things, again, nothing's particular, but when we start to roll them together, we start to think, there might be something here. The recognition is your first step. Know individually what your next step is. Do something, because if I don't say something, that kind of just means, I'm okay with somebody being high at work. None of us are. But our employees need to know, if you don't tell me what's going on, you're pretty much saying, okay, we're just going to roll the dice and hopefully everything works out here today. So end of my time, my contact information, Lisa's got that for you as well. You'll have copies of the slides. So let me get out of here so we can
Perfect.
talk about, all right, am I out?
You are out, and if you want to turn your camera back on, perfect. Thank you so much to Craig and Don. We do have a couple other questions that have popped up that I did not ask. One is, what is considered an open container when referring to cannabis?
Anything that's not in the original package, essentially. Or if it is in the original package, the seal is broken and then some of the contents are removed. So and again, I try to equate things to alcohol and not rarely do things with alcohol and marijuana equate, but I have a can of beer and the top's not cracked. That's not an open container. I pop the top. It is now an open container because the seal is broken. If I have a bottle of whiskey and I unscrew it and I take some of the contents out, that seal is broken. That is now an open container. I hope that helps. If it doesn't, feel free to add the rest of your question if you need. So.
Well, and another way too is gummies are a big thing right now. If that seal is broken, that's an open container. If that package is broken, if that bottle is cracked, that's an open container, needs to be in the trunk. Okay. The next question. Oh, here's a CBD question. With low dose items that are topically used by many people, they may also show and trigger a positive, correct?
Yeah, and the big thing with that is nobody's watching the gate on that stuff.
Correct.
They're not supposed to have much THC in them, not enough that would get you to hit on a test. But I've seen two different studies, one in the US and one in the UK over the last handful of years. Over 50% of the substances, the products that they tested on both of those came back with more THC in them than they're supposed to have. So somebody that's using that, I'm rubbing a lotion on my elbow, should, a CBD lotion, should they test positive? No. Will they? Maybe. They might.
And that's a good point that Don pointed out. CBD is not FDA regulated. And therefore, that is where THC is showing up in many of those CBD products that say there is not THC in them. So be careful because you're taking a chance by utilizing.
Absolutely.
Beyond the DOT, are there any situations where federal contractor would be required to test for THC? How does this affect subcontractors, staffing companies placing temporary client with federal contract? If you are federally employed, this law does not change for you. All federal employees and DOT employees, marijuana is still a Schedule I. And I'm going to leave that to Don and Craig to extend on.
I think the question may have been whether you are, as an employer, required to test those people for THC. I'm most familiar with the Department of Transportation regulations for there's a variety of different sectors, but commercial drivers being the biggest one, implemented by the Federal Motor Carrier Safety Administration, but pipeline operators, shippers, airline pilots, etc. I don't have deep experience with other sectors, but I think like nuclear power plant operators and some other areas, they have mandatory drug and alcohol testing. I don't really represent clients in those industries. I am not aware of, but I could be wrong, I'm not aware of a general federal law that requires federal contractors to test all employees for drugs or alcohol, including THC. And there may be some narrow requirements in certain sectors. Most federal contractors are covered by the Federal Drug-Free Workplace Act, but that is not a testing law. It basically says you have to have a policy that prohibits your workers from, being under the influence of, using, possessing, transferring, trafficking in illegal drugs at work. It doesn't prohibit testing, but it doesn't require it either. So I guess you would have to really drill down deep, depending on your industry, to see if the federal government is requiring you to test certain employees in your company.
Thank you. And the next one is, can you test people under the age of 21 for cannabis for pre-employment since it is still illegal for them?
Whoa, that's a good question.
That's a good question. I don't know the answer to that one.
Dump the attorney.
Yeah.
Let me pull
Dig
up.
into that one.
I'm gonna pull up my slide. I'm gonna multitask. So let's come back to that one.
Yep, sounds good. Okay, Peyton, we're gonna get back to you on that one. For safety sensitive positions, if the result of a random urine test is positive, an employee states they used recreationally over the weekend, does the employer treat this as a positive result or require a blood test?
I think it's a positive result. At that point, so if you are allowed to conduct the cannabis test, you then can discipline and in some cases even terminate for failing it. They can't say, oh, I got a free pass because cannabis is lawful and I used it over the weekend. But again, there are limitations. For example, it's a first positive test, then you have to refer them to an evaluation and, if appropriate, treatment, counseling, rehab, and you cannot terminate if you either have not done that or you have done that, but they've agreed to participate. So, but in a general sense, when I have throughout my slides, if I said you are allowed to lawfully test for cannabis under this circumstance, if they fail the test, you can discipline them short of termination. And in some cases, you could even terminate if it was a second positive test, or you refer them to an evaluation, and if appropriate, counseling and rehab, and they refuse to participate or they fail to complete it. But this recreational marijuana law, it's not a free pass to every positive test. If the test was lawful, it's still positive, it's still, problematic for them, if that makes sense.
Here's one. Would corrections officers or 9/11 operators be universally considered a safety sensitive position? Does anyone know what the state is categorizing them as? I can find out that second part, but if somebody would like to talk about the first part, my suspicion says yes, correction officers would be universally safety sensitive, but I'll let the experts answer that.
I would tend to agree. You'd have to kind of think about it position by position and if there's special positions within that category. But in general, I think you could make a strong case that a corrections officer, safety officer, police, firefighter are all safety sensitive.
And one question did come up earlier about receptionist greeting, being the face of the organization and greeting the public. And would that be considered safety sensitive? And can we just deem everyone in our organization as safety sensitive? You have to be very, very careful with that, because if you deem everyone as safety sensitive and a positive triggers and the courts and it goes somewhere, it could be litigated because they could say my job isn't safety sensitive, and now you're kind of in a loop. So I will also defer that back to Craig and Don, but that is my understanding of the law.
Yeah, if you call somebody safety sensitive, you have to be able to back that up. Eventually down the line, maybe, should that become an issue about whether that person was disciplined appropriately or not, you have to be able to argue that yes, they are when we look at the definition in the law. And then I read that question earlier when Craig was talking, and with respect to the reasonable suspicion piece, and right now, because again, my opinion that a little bit of the oversight there that we can't test. If you want to test that receptionist, that piece of the law needs to be fixed. And again, my opinion is it probably will be because I think it's an oversight. So that will fix that whole piece because I think the concern is I can't test my receptionist right now. Well, yeah, because of that little bit of hiccup in the law there. Should that get fixed, then yes, you can from a reasonable suspicion standpoint. So I don't think the answer is let's make everybody safety sensitive so we can test everybody. I think the better answer is let's go back and make sure that the law is doing what we think it's supposed to do. And then we just kind of revert back to the whole safety sensitive as one set of folks. And then the reasonable suspicion catches the non-safety sensitive folks. Again, my opinion, reading the law and my understanding of it.
So I would generally agree. So you should not just classify every employee as safety sensitive so that you can test them on a reasonable suspicion basis. I don't think that's going to fly legally. You have to meet the statutory definition, which admittedly is a judgment call, but I think a receptionist is likely not going to be considered safety sensitive. Now, there's sort of an implied question, at least in the version of that, or an implied premise in the version of that was on the text or the chat chain, which is kind of like, oh my gosh, this is ridiculous. You mean we can't do anything? I'm not saying you can't do anything if the receptionist is high at work. I'm saying you can't test her. There's a difference. You can discipline her. You can even fire her if you think that she's impaired at work or using, possessing, selling, transferring, trafficking cannabis or other drugs or alcohol at work. But if she's high at work due to the fact that she smoked legal cannabis prior to her shift at home off of your premises, I don't think you can test her, but you can discipline her and probably, you can discipline her. So the question the glitch or whatever that Don mentioned in the statute, which I tend to think was an oversight, but I'm not sure. I just don't know because
know.
they very clearly reworded the statute under every category of testing. And when they wanted to allow cannabis testing, they added cannabis testing back in as a category, and it just doesn't show up in that particular subdivision. As to the question of, can you conduct pre-employment cannabis testing for a job applicant who is younger than 21? I think the answer is probably no. I have not done in-depth research, but the reason I think it's probably not permitted is that there's statutory language that flatly says that an employer must not request or require a job applicant to undergo cannabis testing solely for the purpose of determining the presence or absence of cannabis as a condition of employment, unless it's required by state or federal law. So you can't go back to the hook of saying, yeah, but for this job applicant, they're 19, cannabis is still illegal, unlawful for them. So I'm going to treat it as a drug test, a pre-employment drug test. The problem is you're going to walk into this language that just says straight out, you can't request a job applicant. And it makes no distinction between, the age of the job applicant. So my inclination is to say you probably could not do it. That's an area where perhaps the legislature might amend it down the road.
Thank you. We have some really good questions coming in here, so I'm going to try to get through these in lieu of time. For those of you who want to stay on the line, we will answer these last few questions before we wrap up for the day. Could someone argue that they use medical cannabis if the test came back positive? Medical cannabis has to be, your employer needs to be told about that and a script needs to be provided, but I also will defer to the experts.
If you're on the patient registry, that is considered a legitimate explanation for the positive test. So on the back end, after you notify the employee of the positive test, which is one of the procedural requirements of law, you also have to notify them that they have the right to explain the positive test. And under the medical marijuana law, the fact that they are properly registered in the medical marijuana registry is considered a valid explanation for the test.
And specifically the statute, it says unless they're impaired at work.
Mhm.
So the presence of is different than the impairment piece there when we talked about the medical marijuana.
Okay, do you have to identify your safety sensitive positions in your policy? You have to identify safety sensitive positions in their work description. In their job description, it needs to be deemed safety sensitive. Does it have to be in the policy, Craig?
Well, I might quarrel a little bit with what you said. The law does not state that this must be in writing anywhere, whether it be the job description or the policy. My strong advice is to put the definition of safety sensitive into your policy and include specific job, descriptions, not descriptions, but job titles or positions that you are absolutely going to deem safety sensitive, but then have some catch-alls, right? Like any position involving the use of heavy equipment or machinery, any position involving, operating a motor vehicle. So you can try to be specific. Like if you know that your company has, 32 different positions and you know that, 11 of them you absolutely deem safety sensitive, then you should, as a matter of good practice, best practice, and to protect yourself somewhat legally, put that in your policy, but then have some wiggle room as well to include, these kind of catch-alls because, your positions might change, you might add roles, your industry or your business might evolve. And you can also make sure to put in, the kind of the broad definition of management level employees whose essentially their judgment being impaired would threaten the health or safety of any person. So I would say my strong recommendation is to put it in your policy because then you'll have a stronger case to defend it later if the employee legally challenges it. But there's not an explicit requirement in the statute that says you must spell out down to the job title every position that you deem safety sensitive. That what does say you must describe the circumstances under which employees will be tested. So you definitely have to say if you're in a safety sensitive position as defined broadly, the definition that I put on this slide, you can be tested on a reasonable suspicion basis. Well, again, with the quibble, not necessarily for cannabis for everybody. But there's no granular specific requirement. You have to like list every position.
Thank you. If our drug policy now states that everyone in the company is drug tested to start employment and random on quarterly basis, do we need to change it for non-safety sensitive employees, or can we continue to test everyone for alcohol and any drug, including cannabis?
Okay, there's a lot in there.
Mhm.
Pre-employment, it sounds like presently they're testing for pre-employment drugs for all positions. You can't do that anymore after August 1st. After August 1st, you could conduct pre-employment drug testing for controlled substances other than cannabis for everyone. And you could test pre-employment for cannabis if they're in one of the 7 lucky positions, as I call it. Okay. Beyond that, under the statute, you can test pre-employment for alcohol. However, it's a horrible idea. We didn't talk about it today, but I strongly discourage you from doing pre-employment alcohol testing because it's only going to detect their lawful consumption of alcohol, which is a lawful product, off your premises during non-working hours, and arguably might fly in the face of the Lawful Consumable Products Act. And furthermore, it can create potential claims under the Americans with Disabilities Act and the Minnesota Human Rights Act because it protects people who are alcoholics as well as people who are erroneously regarded as alcoholics. So if you refuse to hire someone who fails a pre-employment alcohol test, is it because you assume they have a drinking problem? Well, if you do, you're almost like admitting that you're refusing to hire them because you perceive them as an alcoholic. So I would highly discourage pre-employment alcohol testing. I think the second part of the question was, we are presently randomly testing all employees for drugs and alcohol. Well, even before the recreational marijuana law, that was not allowed unless in your particular company, every single position is safety sensitive. Because under the current state of the law in DATWA, you can only conduct random drug or alcohol testing if the person is safety sensitive or a professional athlete, essentially. So I'm assuming these are not professional athletes. So if you're doing that already, that is potentially a no-no, unless, hey, you know what, maybe your company is, a contractor out in the field and every single person is in the field doing, heavy construction or whatever. All right, if that's the case, that universally A to Z, every single employee fits safety sensitive, then you could test them on a random basis. All right, so fast forward after August 1st, after the effective date of the new law, can you do random testing for everybody? No, it's more narrow now than it was before. And I'm pulling up for my benefit the random section. Whoops. Now allows drug, alcohol, or cannabis testing, but just for the safety sensitive positions or the professional athletes. So nothing really has changed with respect to the legality of random testing.
Okay. And I'm going to go with this one last question and then we'll wrap up. Well, we can test the Lucky 7 for marijuana after 8/1. Are we required to?
This law does not require any employer to test for drugs, alcohol, or cannabis. DATWA never did. You may, however, be required to test under a different legal authority. Presumably, most likely, if you are, it's under DOT, but there are other regulated industries. Department of Energy, for example, regulates nuclear power plants. And there's some other industries where there may be mandated drug and alcohol testing, but at the state level, under DATWA, the state legislature is not telling you either before or after the adoption of this law that you must test anyone. They're really just limiting your ability to test if you so choose.
All right, this was awesome. I just want to thank Craig and Don again. I'd like to remind all of you that on July 10th, Craig is going to be doing a session specific to safety sensitive and what that entails. On July 11th, Don is going to be doing a session specifically to reasonable suspicion. Both of them, again, are only an hour and we'll be scratching the surface. Beginning August 1st, we are going to be doing in-depth training, and we picked August 1st for a reason. Where both Don and Craig will be together in a 4-hour program. So watch your emails. Stay tuned for that information. I will be sending that out in your wrap-up email, along with copies of their handouts, the recording, and then these upcoming webinars. Thank you all for joining, and have a safe and great day.
Thanks, Lisa.